Every day in the USA, people find themselves in court.
We are taking up the matter of, well, it started as a DCF case, I believe, but at any rate, Monica Ashdown versus Stephen Gulick. It is a Greenwood County District Court case, 18 DM 69, which is part of the reason that's being heard by Zoom today. This is not a Greenwood County day for me. I previously entered some emergency orders in this matter with regard to the minor child on, I think it was April 13th of 26. Have a lot of notes, 2 pages of notes by my AA on this case. And based on the motion to modify parenting time and notice of hearing that was sent to Mr. Gulick by the petitioner, they are both self-represented. Ms. Ashdown is representing herself. Mr. Gulick is currently representing himself in 2018 DM 69. So this is not a new filing. Personal service was obtained, not just notice of hearing, which is sufficient. Personal service was obtained on March 19th of 26, advising that the motion had been filed and a notice of hearing with all of the Zoom information. It was originally scheduled as a Zoom hearing. The notice of hearing was filed in the court file on 3/13 of 26 at 8:14:08 a.m. By the petitioner. All of these records are a public record, which can be accessed through a portal or at the courthouse in Greenwood County. There's nothing concealed. It was also sent to the home, the known home address and work address of the respondent father. The motion to modify parenting time was filed on March 6th and an amended motion on March 11th, and a month later, the hearing was held. I started the hearing on time. The respondent never replied in writing in any form or fashion to the motion to modify, to the allegations in the motion to modify, to deny anything or enter an appearance. And then he did not show up at the hearing at the appropriate time. Now he is so I granted it by default judgment, although I advised the petitioner mother that she needed to provide me with documentation from a therapist so that I had something substantive in my file with regard to the changes that I made at the time. But ordinarily a default judgment, whatever a petitioner attorney or a petitioner asks for and prays for in their motion or their petition, by default, it's granted when the other party doesn't appear. But I went a step further and heard the allegations, considered them, and asked for documentation, which I have received from the child's therapist since then. I also ordered the petitioner to journalize the hearing, which is what parties are supposed to do when they're self-represented and there's no attorney, because that's what the attorneys do. When they prevail on a motion, they submit the order. I don't know too many courts where that isn't the case, in Kansas anyway. So I'm trying to look for this order though. I know it's in here. Yeah, it's pretty short. The order modifying parenting time was signed by me on April 13th. So it was submitted on April 13th and signed by me. And it is currently in effect. On I believe I waited, I don't know, 10, 14 minutes or something for Mr. Gulick to appear. And I inquired of my AA, has he communicated with you, given you his email, told you that he's going to appear at the hearing, asked for anything additional with regard to the Zoom or the link? That is standard questions that I ask. Check with the clerk's office. Has anyone before now received anything? And I don't remember if I asked that particular question, but I did discuss that I wanted to make sure that you had proper information and whether you had reached out, because in addition to not appearing as a default, I also considered the fact that you didn't file any responsive pleading in this matter. I did not communicate with you because I can't ex parte communicate with any party. And what ex parte means is I'm just talking to you, or I'm just talking to Ms. Ashdown separately from the other being present. I can't do that with attorneys. I can't do that with parties. So usually things are filtered through my AA. And unfortunately, sometimes she ends up in awkward positions because she can't give legal advice. I don't give legal advice. I can't give legal advice. But we do try to tell people what their options are, legally speaking, and then the rest is up to them. So my understanding is, Mr. Gulick, you, my AA didn't hear directly from you till, or receive messages from you till after the hearing. However, you made allegations that you were sitting in the conference room, or in the waiting room, I guess I should say, as part of the Zoom proceeding.
Yes, Your Honor.
And she double checked. She advised me that, and I'll ask her a few questions here in a few minutes, but she advised me that she gets an alert when someone enters. And sometimes folks can be kicked out. That's the only thing that I don't like about Zoom hearings is when I said it in court and somebody doesn't walk into the courtroom, they can't make any other allegations. They either went through security and entered the courtroom or they didn't.
Exactly.
But we have no evidence prior to the hearing or when the hearing commenced that you were attempting to or in the meeting, or that you had any intention, because you never indicated any intention to participate. However, you were advised that the proper procedure, if you were unhappy with the court's adoption of the motion, that your alternative, I wasn't going to just set a new hearing. Again, I don't do that with anyone. They then have to file a motion to set aside a default judgment. You did file that on 4/14. And this wasn't sworn to under oath. So I'm going to put you under oath and I'm going to ask you these questions. So raise your right hand, please.
Yes, Your Honor.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. Please tell me in your words what happened that day that you believe supports the court's setting aside the order that it entered in this case as it pertains to your child?
Yes, Your Honor. First of all, I would have never missed this hearing, Your Honor. I was up first thing that morning with an alarm and my father right behind me, just like my mother is right now.
I'm sorry, who was with you?
My mother.
I know, who was with you that day?
My father, Billy Gulick.
Okay.
Throughout this whole thing, I've made sure to have a witness with me the last year since all of this has been going on. That way it's not hearsay, she say things. That's trying to learn from my mistakes. I sat here, I waited just like I did this morning in this room. This morning I learned from my mistakes also. I took a picture, sent it to Miss Amy, let her know that I was on 15 minutes early again. Last time I got on, once I got on, I noticed the screen said that I had to have the 2018 case number and all that on it. So I instantly logged out, logged back in with that on my name. And I sat there and what it said, I took pictures and everything. I sat there in that same exact courtroom that I was just in, waiting and waiting until I freaked out about 15, 16 minutes in. And then I started blowing the police station up and everything.
Okay. So do you have those pictures on your phone time-stamped or on your computer or on your iPad or something? Those pictures you took of yourself, do you have them time-stamped that you can present to the court?
The only one I have, I sent to Miss Amy. I don't know if it's Mrs. or Miss, sorry. Or
Ms.
or Miss.
Ms. always works. MS.
Okay.
Ms.
Yes, ma'am.
Okay, that's fine.
And it did show a later timestamp because I did not take a picture of it until I realized after I had messaged Miss Ashdown asking if she was still waiting as well. And her reply instantly was, no, you missed court. Order's been signed. And I started freaking out. I started calling the cop station. I'm letting them know I'm still sitting in this courtroom. I'm literally right here on the screen. I did not miss this. I would never miss this. I had my witness with me just like I do today. I was here 15 minutes.
Okay. So we're clear. You weren't at the courthouse. You were at home, correct?
Yes, on my
so there's no sheriff's deputy or court personnel that could attest that you were at the courthouse. So you were at home, correct?
Yes, ma'am. Yes, Your Honor.
You do not have, just so I need the record to be clear, you do not have an actual picture time-stamped of you in the waiting room, either before the hearing started, during the hearing, or before I concluded it.
It was not before you concluded it because I was told you concluded at like 9:40 something.
Yeah.
I think the picture I sent was at 9:49.
Okay. So the answer to the question is
no.
Yes, you do not have a photo of you sitting on Zoom from the time it commenced to the time it ended. It was after.
Yes, Your Honor. I tried to contact Zoom and they informed me that because I am not the person that runs the room, I cannot get the record of attendance that day. I understand that you don't have any record, but the record should show, even if she didn't see me, that I have logged in from this computer at that exact time I stated. And it should also show that I logged out the exact same time I stated and logged back in with the current information, my name. And Zoom wouldn't get to that.
Okay. And do you have your dad there that was your witness on the 13th of April to testify today?
No, he called and everything and made a report to Miss Amy as far as I know. He is 40 miles away at work right now. That day that I was up there, my brothers live right next to where I work and I was living with them at the time. And then after that, sorry.
No, that's okay. But understand that I can't consider those things if they're not here to be under oath and testify before me.
I had no idea, Your Honor, that he was here.
I know that is the problem with folks representing themselves, is they don't have an idea, and I don't expect that they should have an idea. But
Your Honor,
when you have witnesses, then they have to be produced to testify, or it is hearsay because it's an out-of-court statement intended to prove the truth of the matter. And the person has to be sworn in, testify in my presence in front of me, and subject to cross-examination by the other side.
Yes, Your Honor.
All
I am
right.
so.
So I'm gonna look at this motion. It states that 9:10, you logged in. You were prompt to give the passcode. That passcode is no secret. That is we don't like everyone to know our passcode because necessarily we don't, advertise how we do it. But because people have gotten into court cases and posted things and done all kinds of, frankly, disgusting things to judges that are having hearings. But the truth is that we basically use one password for our Butler and our Greenwood domestic. So again, we're not hiding the ball, changing it for every hearing, making it difficult for someone to have the information to participate.
Yes, Your Honor.
Okay, I read the cautions on the screen. I logged out. That is true. Part of the reason you have to input this information to participate is for that reason. Again, we've had people, I don't know what you call them, stalkers, I don't know what you call them, but we've had people who come in, we can't identify who they are, and they disrupt proceedings. So that's why that policy changed to, we want to know who you are. We want you to log in, tell us what case you're here on, and who you are before we put you in the hearing or the meeting.
Yes, Your Honor.
All right. So I'm just trying to explain to you so you or people don't think that we're just making these things up to make it hard for people to have access to the courts. That's not the intention.
Yes, Your Honor.
All right. All right. And so you're asking the court to set aside its ruling and to give you a hearing on the motion to modify.
Yes, Your Honor.
Okay. Now, Ms. Beckman, I know I didn't prepare you for this and I apologize, but I do, I've had to testify as a judge before. I've had to testify as a prosecutor. I don't like it at all. So I'm sure you don't like this and I didn't subpoena you or forewarn you, but you've got a pretty lengthy notation and record of what transpired, and I know you have a habit of doing that in all cases. This isn't the first time that someone has said they tried to get in or get information and couldn't. I'd like it to be the last time, but I don't know that it will be. But I do want you to sort of, I'm gonna put you under oath, but I want you to kind of summarize what you did to verify one way or another, Mr. Gulick, and how I don't run the system. I don't even really know how it works. That's what you do. I mean, I have an idea, but because I'm participating, I have an idea, but I certainly am not, like, I wouldn't operate the whole system on a daily basis or anything like that. So, Ms. Beckman, if you raise your right hand, you do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Do you have the 413 notes before you?
I do, and I also have the recording from April 13th.
And by recording, do you mean your conversation with him or the hearing itself?
No, I never spoke to him on the phone. I pulled the recording from April 13th, and the time that it was started was at 9:29 a.m.
Okay.
The recording was for 13 minutes and 52 seconds. It is the same link that was on the notice as well as the same link that we're using today.
Okay.
When I start the hearing, if parties are in the waiting room prior to me. The photo that Mr. Gulick sent to me today, as well as previously, which I'm looking at that photo as well. It says Judge Jan Satterfield, BU, GW, EK, domestic cases, waiting for the host to start the meeting. That is an accurate photo of what it looks like for parties to enter the meeting or the waiting room prior to me starting the actual hearing. As soon as I start the hearing, they will immediately come into the waiting room. And there is a sound that sounds over my computer that sounds like a doorbell. And it goes off for each party that comes into the waiting room. When I started the hearing that day, Miss Ashdown was the only one that was in the waiting room. Excuse me. The photo that I'm looking at from Mr. Gulick, it says Monday, April 13, and then there's a 10 for a time, and then it's cut off after that, which would have been after the meeting had concluded that day. Looking at the notes entered on 4/13, respondent called the Greenwood County Clerk's office and a message was received from one of the clerks over there to me at 10:07 a.m.
Which clerk was that?
Miss Pettigrew,
Okay. At what time? I'm sorry.
10:07 a.m.
Okay.
And her message had indicated that he had stated to her that he was waiting in the waiting room since 9:15 that morning. And she stated that she confirmed the meeting ID and passcode with him, in which was correct. I had a message from Misty Neighbors over in Greenwood at 10:22 a.m.
And so Miss Pettigrew is in the clerk's office, correct?
Correct.
Miss Neighbors works for the Greenwood County Magistrate Judge over there.
Correct.
Okay. So separate office,
Correct. And both of
separate phone lines.
correct.
Okay.
And both of these messages came to me from Teams.
Okay. Which is a computer program that everyone can tell me what it is exactly.
It's just it's our internal court messaging system outside of email.
Okay. Go ahead.
Missy's message was sent to me at 10:22 a.m. stating that dispatch had called and stated respondent called them and he was in the waiting room and they advised him to call the court. The first phone call that I received from Mr. Gulick was at 9:50 a.m.
Freaking out.
Okay. Please don't speak, please.
Sorry.
All right. Go ahead.
He had also indicated in his voicemail that he had been waiting in the waiting room since 9:15 a.m. And then I received an email from him at 11:10. If you need more detail with regard to that, I can give that. Then I reached out to our court administrator.
Okay. And basically he said in his email to you that he had, the paperwork he had been given to him. I was online with the paperwork given to me 15 minutes before court. I used the info that was on the paperwork delivered by the officer, and I made sure to add the case number on my name when I logged it. And then you responded to him at 11:27 a.m.
Correct.
And what did you tell him? That was the information that you had been receiving up to that point.
I had indicated that I had received a couple messages from the clerk's office in Greenwood County stating that he had indicated the same. I told him that I do not take calls or return calls while we are in hearing. This hearing was started at 9:30, which is It was started a minute prior to that. It was started at 9:29 according to our Zoom records. I did not have any missed calls nor voicemails prior to the hearing, nor during the hearing. I did not have anyone in the waiting room while the hearing was in session. The system notifies me by sound when an individual enters the waiting room while a hearing is in session. I checked my phone prior to the conclusion of the hearing as well. The judge granted the motion based on no answer having been filed by you as well as you not appearing. I will advise the court of your email and voicemails as well as have it noted that the first missed call from you was at 9:50 a.m.
Okay. And if someone is in the waiting room before you open the hearing and get started, as he indicated, he was waiting, he didn't try to come in. He's given no indication that he tried to come in during the hearing. His testimony is that he was in prior to the hearing starting. So if that were true, would you have still heard the noise? Do you have to let him in, or is he automatically entered as a waiting party?
If he is logged into the Zoom on his device prior to me starting the hearing, it will show what his photo indicated. As soon as I start the hearing myself as the host, it automatically kicks anybody that's waiting into the waiting room, and I have to admit them. However, it does notify me by, I'm pretty sure it's the sound of like a doorbell for each person that comes in. And then it sends me another notification sound that's different as soon as I admit them.
Okay.
And if he had logged in while that session was going, it still would have notified me whether or not I had something over the Zoom or not.
Okay.
Let me find.
All right. And okay, so what follow-up, if any, did you do with administration to consult any? All right, let me rephrase this. You are confident that you didn't just not admit him and he was there to participate, correct?
100% confident.
Okay. Then what did you do to verify with a third party outside source or attempt to get information with regard to the Zoom information that he stated he was unable to get?
I reached out to our court administrator to inquire if there was a way, because he had indicated in one of his emails that he was going to contact Zoom, or he had maybe already contacted Zoom. I don't remember without looking back at it. So I contacted our court administrator because the only thing that I can see on our end is when the hearing was actually started, how long it lasted. So I reached out to our court administrator and inquired further if there was a way to track the timeframes or participants of when they're entering, leaving, so on and so forth. At 3:32 on April 14th, 2026, our court administrator, Don Rouse, had forwarded me, let me open it real quick, an Excel sheet. Get it to where it's not a bunch of symbols. Okay. This Excel sheet shows origin name, Amy Beckman, AA. And it shows the email address associated with our account, which is yours, Judge Satterfield. Join time, 4/13/26 at 9:29 a.m. Duration, 17 minutes for myself. In waiting room, it says no. Then there is Monica Ashdown, 4/13 at 9:30. Duration, 1 minute. And then at 9:31, Monica Ashdown, 4/13 at 9:46 a.m. Duration that she was in the meeting was 16 minutes. And then it shows yourself, Jay Satterfield, 4/13 at 9:32 for 14 minutes. Those are the only participants that are in from the start of the hearing to the end of it. I responded to our court administrator at 3:35 and I inquired if there are parameters that can be entered beginning at 9 a.m. to 10 a.m. to cover the time frame that he had indicated that he logged in at 9:15 until following his first phone call to myself. She had indicated, no, it is by meeting. Then it lists those that hit the waiting room during that specific Zoom meeting. So in essence, the Excel sheet that she sent me is from the time that I started the hearing until the time that I ended the hearing.
Okay. All right, and let's back up a little bit here. You did send email to Mr. Gulick at 12:10 p.m., so right after the lunch hour, that you would, as you indicated previously, advise the court, advise myself with regard to the matter, which you had, which you did again.
Correct.
And you advised me that at some point, maybe not this point, that you had told him what his options are, which is to file a motion to set aside the default judgment that I entered in the case. I believe he testified that he was blowing people up. Did you make any notes as to what all he was doing after he learned that the hearing had been concluded?
Yes, I received a response from him at 12:33 after I had advised him. At 12:10, I said, I understand, and as I had indicated previously, I will advise as soon as I am able to speak with the judge regarding the matter. At 12:33, he had sent an email saying, yes, I am sorry for blowing you up. I wouldn't miss court for the world. Our daughter is my world and means everything to me. And then I have a note in here that I had advised the judge of the night. I received 19 phone calls, voicemails, and emails.
Okay.
And then at 1:44 is when I had responded to him and advised that you may file a motion to set aside the final orders entered today. Upon filing and review of the judge, a hearing may be scheduled on your motion.
All right. And when was the last contact that you had with Mr. Gulick, other than setting up this hearing for today?
I received a response from him following that email at 1:50, and he said, so if I get with Zoom, have them pull the record showing I was there, that would mean nothing, ? Another email that I received from him at 2:06 stated, you cannot enter a court Zoom room without the password. There's record of me being there in time, I promise. I responded at 2:29 p.m. I said, Mr. Gulick, I do understand your frustration and apologize for the same. This hearing was started at 9:29 a.m. and was on the record for 13 minutes and 52 seconds. I have provided the judge's directive. If you wish to file a motion to set aside, please let me know when such has been completed, and I will provide to the court for review and scheduling. Thank you.
Okay.
And I believe that was my last communication with him that day at 2:29 p.m.
Okay. Mr. Gulick, do you have any questions of this witness with regard to her testimony?
No, Your Honor.
Ms. Ashdown, please raise your right hand. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. I don't want to go over any discussions you may have had with him about the motion, even prior to the motion, because I have sufficient evidence in my file to take judicial notice of that you gave him proper notice of the hearing and that you sent him the motion. And he does not dispute that he had the information. He had the date, time of hearing. He had the Zoom information. He understood that the hearing was by Zoom. So there's really no dispute about that. So all I want to ask you about is either during the hearing, after the hearing, at any time, did you get contacted by him with regard to the hearing?
Yes, it was after the hearing had already concluded. It was, I want to say, a little after at least 9:50. I had received a message on Our Family Wizard, and he had asked me if something along the lines of if Zoom had me waiting, and I said no. You missed the hearing. The order will be filed this week. And um, then I can't remember what he said after that. He was, as he, in his own words, kind of blowing me up. Not so much message after message, just that I was there, I wouldn't miss this type thing. And I can't advise him on what to do. I don't know what to tell him what to do in this situation. So a lot of those messages just went unanswered because it's not pertaining directly to our daughter. It was pertaining to this court case, and he missed it for whatever reason. That's beyond me.
Okay,
That's
so just so we're clear, Our Family Wizard is what?
That is the parenting app that we use to communicate. And we have an order from the court for that as well. Just because it's been so hard to keep a consistent communication base with Mr. Gulick. I wanted to have one space where it would always be, and where if we needed to, the court could access that.
Okay. Well, actually, I don't have all your password here. I can't access
Well,
it,
but
you can produce it for me.
Yes.
And it is commonly used in Sedgwick County and some in Butler and a little bit in Greenwood County too. It is something that can be monitored. And I also think even perhaps it's monitored enough by the company that if there was, not 100% sure on this, but I think if there was threats made or something very disturbing or alarming, that they could notify the court. But otherwise, it is information you have to retrieve, but it is documented. And I think courts use it to try to keep people on their best behavior. And if they're not, there's, saved evidence. There's a lot of things that are available, but then, they're deleted or not available after it's happened, or after a short period of time. And this program is intended to save information. I know you pay a fee at some point. I don't know if it's a monthly fee or a yearly annual fee or anything. I don't know if they tell you how long they save stuff, but I'm assuming indefinitely, as long as you're a participant, a legitimate participant of the program, based on whatever fees they charge. Again, I generally understand these things. I don't intimately study them and know all of the ins and outs unless I need to, unless I have to investigate something, frankly. But at any rate, is there anything that you wish to add?
Not that I can think of, Your Honor.
Okay. Mr. Gulick, do you have any questions for this witness?
No, Your Honor.
Okay. And you have no evidence on Our Family Wizard that any time in the month from when you got notified to the hearing that you indicated in Family Wizard to Ms. Ashdown that you would be there, and you would be participating in the hearing, correct?
I would have to go through all of our messages. We don't talk a whole lot about that kind of thing.
Okay.
We both know better to talk about the court case.
Okay.
I'd have to look, and I actually messaged her the first time it was like 10:02 from when I'm looking at the messages right now. And then after that, I told her that I was there. And then I sent her a picture of the exact courtroom that I had been waiting in. And it's the exact courtroom that I was in this morning.
Right,
But-
but again, it was time stamped a date, a time after the hearing had already concluded.
Yes, Your Honor, but
Okay.
being in
No,
that,
I understand, but you gotta be clear. There is a difference. If you had, if you were sitting in there, where are they? I know the hearing started because I see what time and I can't get in and I'm taking a picture and I mean, I just want the record to be clear that you do not have a picture during that 13 minutes of hearing that we had.
No,
Okay. Ms. Ashton, I noticed you raised your hand. Is there something that you wanted to say?
Yes, I want to say it was either the day before or 2 days prior. It was either the Saturday or the Sunday before. I did message Mr. Gulick on our Family Wizard. I copy pasted the information directly from the email to that message, and he had stated he would be there.
Okay. Well, I appreciate you sharing
Your Honor. The message she's talking about is correct. I just found it and I told her, thank you very much for the reminder.
that. Okay. All right. All right. Anybody want to call any other witnesses or add anything?
I can,
All right. Well, legally speaking, since I'm the judge, there are a couple things I want to say. Premises that I have to work within, frankly. One is that parents have a right to participate in the co-parenting of their children and essentially have a constitutional right to raise their children. So I just have to say that's a very general premise and rule across the country. It's been found to be a constitutional matter, not just in Kansas, but with the United States Supreme Court. So that is a premise that I recognize. There is also a premise that I recognize, which is courts need to have and need to see finality of matters. So people can't typically show up whenever they want, get heard whenever they want, bring new matters up whenever they want. I mean, for instance, to modify a parenting plan, there needs to be a basic prima facie showing of a change of circumstances that might warrant it. Or there are other legal matters where there is a basic fundamental hurdle that has to be made before you get to a hearing. And that is so matters are not constantly litigated. And the courts have found that with custody litigation by and large is not in the best interest of children because children feel the stress. There's generally things that happen. There's just a common position across, I think the country probably, but certainly within this state, that domestic cases, it does not benefit being in and out of court constantly as it pertains to children in domestic cases. The last provision that is a principle for the court to consider, frankly, is that the courts have found that it is not preferred that district judges, tribunals make decisions based on default. In other words, it is preferred under the law that matters be heard on their substance, on their merits, and not because one party did or didn't show up, which is why often with certain things like divorce decrees and that kind of thing, if someone doesn't answer, doesn't participate, they can come in within a year and ask if they have a good faith showing and cause for it to be set aside. And that's a reason I would prefer not to find those, because I think that there needs to be finality to proceedings. Specifically as it pertains to children. And that's why adoptions have certain principles that make it final, that it can't be set aside without greater showings than just, hey, I didn't get good notice. That's usually one reason you can set it aside. I don't think there's any issue about notice here. I frankly really have no doubt that for whatever reason, you were not logging in during the period of time from the commencement to the end of the proceeding. Maybe, I don't know if you entered very early and just sat out in space somewhere before the meeting started and people were let in. I don't believe that, but I don't believe that you were logging in and out during our proceeding and it went unnoticed. I do not find that. I do not believe that. Now, based on the premises that I've stated, the question is what premise does the court put more emphasis on in terms of either granting or not granting the motion to set aside? And additionally, I have to note on the record that custody cases involving children are always ongoing for the minority of the children. So until they're 18 or jurisdictions changed, even if there's a judge change, it stays in Greenwood County District Court where it was filed, unless certain factors are presented that the case gets moved to some other jurisdiction. And essentially that requires an agreement or both parties to move out of the state. I mean, it stays within the state. And if one person remained in the county, it would stay, unless there was some consideration by the judge that it was highly, inconvenient. I mean, then you can be changed from county to county. But essentially, again, we covered the 13th Judicial District, and these matters are continuous in nature for a judge in this district until the child's 18, unless the case gets moved out of the district for legal reasons. So I guess what I'm saying, Mr. Gulick, is that even though the court has entered the order modifying parenting time, which I'm not going to suggest that that doesn't have a significant impact on you and your parenting time to some degree, you could file a motion to modify the parenting time after and put in your motion what you believe supports a modification either back to the parenting plan that you had previously or even extends your parenting time. I'm going to go through this with you before I rule on the setting aside, because the setting aside then means that we go back to the parenting plan that was in effect. Then this order modifying essentially is not the controlling order of the court. Right now, the order modifying parenting time does this. Respondent shall continue to have parenting time every other weekend and shall include one overnight. So that there are times that I do emergency orders that suspend parenting time altogether. And I did not do that in this case. And I don't believe that that's what was asked for. Those are when the constitutional questions arise. Is the person unfit? Is the child in immediate danger? Those kinds of questions when they're of an emergency nature and your rights are suspended altogether until further order of the court. I did not do that in this case. However, I did modify the parenting plan to require that your overnights occur at your mother's residence in Reese County, Kansas, Greenwood County. And you've indicated that that may be your mother behind you. And the provision with that was, I believe, mom's understanding that at your mother's house, there's a separate bedroom and a bed that's available for the minor child. Then, the minor child shall have her own separate sleeping space during any overnight visit. If respondent exercises parenting time at his mother's residence, parenting time shall conclude at 6 p.m. on Saturday. Drop off at the sheriff's office in Eureka, Kansas. So I guess even though every other weekend, it's not overnight. Miss Ashton, is that your understanding of what you motioned the court for and the court ordered?
No, ma'am. He will receive an overnight every other weekend on Fridays from after school or 3:30 to 6 p.m. Saturday, if it's at his mother's house.
Okay. And before that, remind me what you were doing in your parenting plan.
6 p.m. Friday to 6 p.m. Sunday.
Okay. So there was some restriction decrease in parenting time, even if he followed the provision of one constant, stable place that the child will be at and stay the night at, and whose home and presence the child will be in. All right. Then, if you are not exercising it in Reese, Greenwood County, Kansas, at your mother's residence, then that every other Friday night would not take place. All right. Then the weekday parenting time. During weeks in which respondent does not have weekend parenting time, respondent shall have one after-school visit per week. Respondent may pick the child up from school 3:30 if school, or 3:30 if school is not in session. Parenting time shall conclude at 6 p.m. that day. Respondent shall provide advance written notice through our family wizard if he intends to exercise this parenting time. So it was not a set day. It was at his convenience with notice that he was going to exercise that day. Correct? Did he, remind me, I don't want to go back and compare and do all of that, please. Remind me what he had, if any, weekday parenting time in your parenting plan prior to this modification.
None, ma'am. No.
Okay. So it did add a day, but not an overnight. It added some time during the week. All right.
May I say something, Your Honor? Am I allowed?
No, not yet. Not yet. Holiday parenting time shall take precedence over the regular parenting schedule. I'm not aware, let's see, April 13th was after Easter. So I'm not aware of any holiday that's occurred since this order got entered. So I'm not gonna look at that at this point. Okay. So the motion that's a previous communication order that I entered on September 16th of 25. I'm sorry, give me a minute here. I'm gonna look at the amended motion, but I don't remember the difference between the motion and the amended motion off the top of my head.
Your Honor, I could clarify that if you like.
Okay,
The amended motion just had the holiday time. The original did not have any holiday time listed in it. I just wanted to make sure it was crystal clear in paper.
did you request a modification of your parenting, your holiday parenting time from your parenting plan?
Did I?
Yes.
So I guess I don't understand the question.
Your motion to modify was basically based on him staying at two different residences, not indicating where he was staying. I think it might be his father's residence or whatever residence in Benton that he was staying at. There may be multiple roommates, but more importantly, that would be random male roommates. That would be that she doesn't have a bed or a room at that location as you understood it. And in your belief, she was struggling with adjusting to the overnight visits, particularly outside of Reese. So that's my general understanding. I'll look at the motion. But what I'm asking is, when you filed the motion to modify the location of the parenting time and the overnights, did you also ask for modification of your existing holiday parenting time?
That's what the amended motion was for, was adding that parenting time or the holiday parenting time.
Okay, so you had no holiday parenting plan before then?
Originally, according to the very first parenting plan, we are set on some judicial calendar. But for the most part, we pretty much work together on the
Okay.
parenting time around holidays, which is how I basically kind of outlined the parenting time.
Okay, so you wanted some set holiday
Yes.
time, all right, which is preferred, especially if there are communication or co-parenting issues. The more definitive a plan is, the better. And frankly, when I have attorneys, which I don't think either one of you have ever had attorneys, have you?
I had used Kansas Legal Services at the very, very beginning of this.
Okay, I now see that. I'm sorry. And you used Ty Wheeler. And for the record, this was a paternity case, right? Not a divorce case.
So we've never been married. No, it started out as like a DCF
Right.
assistance type situation. Yes, ma'am.
Right, that was filed in Greenwood to get him to acknowledge paternity and get child support. Because for whatever reason, you had assigned your rights to the state.
Yes, ma'am.
In order to help get insurance or whatever you needed for yourself and or the child or both. Okay, so they filed an action against him, and you got Ty Wheeler of Kansas Legal Services of Emporia, who helped journalize the parenting time. Because actually, when DCF generally files cases, all they're interested in is getting money. They aren't involved or interested in helping with parenting plans or best interest of the child or anything else. They're collecting money. Because again, generally they're providing some kind of assistance to the family or the mom or the child or what have you. All right. And remind me, there's very few documents that have child information, unfortunately, and it's very limited information. Remind me the current age of the child.
8.
And how old was she? It's a female child. How old was the child when the the action started. I guess 8 years ago.
Yeah, she was fairly young.
Okay. And when was the, okay. And so that was a graduated parenting plan because of the age of the child. And it looks like you actually had Miss Shirley, Marianne Shirley, Mr. Gilly, for a time being.
Yes, Marianne Shirley was on my beginning, Miss.
Okay. Okay. And you have had, and so there was a parenting plan that arose out of that initially. And then there were various child support orders and modifications through the child support hearing officer, not through me. All right. All right. So for your information, and again, it's not unusual for children to be in play therapy or some kind of therapy if there are potential adjustment issues or issues between parents, whether they've been married, not been married. And I'll be honest as well. If I have a parent who is concerned and has filed motions and made statements or allegations, whatever you want to call them, that they're concerned about the co-parenting of the other parent and that they believe it's affecting the child, I strongly urge, either through school counselors, through a mental health facility, through some kind of mentorship or counseling, that an independent professional have some contact with the child to provide substantiation to the court of what is or isn't going on with the child, so that I'm not fully relying on a parent's assertion. And so I do believe that because the motion indicated that the way you were handling your parenting time, Mr. Gulick, frankly, was negatively impacting the child, and that there were concerns, because there is a general proposition that children should have stability, consistency, and
Sure.
Be as safe as we can possibly keep them. So anyway, let me read to you, and then I'll hear from both of you because I want you to make an argument as to whether or not the court should set aside the order, what the court should do in the interim. Should the court set this for a full evidentiary hearing? What do you contest? I'm gonna make some actual rulings, but I'm trying to make the record clear, trying to make sure that I've kind of generally informed myself where we're at on this case, and that I will let you make statement or argument to the court in just a minute. All right, so what I received, which you may or may not have, I don't know. We're usually pretty careful about forwarding information from psychologists, from drug treatment facilities, that kind of thing. And this was marked confidential. It involves Goldfinch Therapy and Wellness. It is from an Andrea Casper Doggett, LSCSW, which usually means a licensed social worker therapist. They're not just a social worker, they're a licensed social work therapist. She apparently is with St. Francis Ministries. The letter was directed to me at my address, sent to me, and it references Melanie Gulick, to whom it may concern. My name is Andrea Casper Doggett, and I am a licensed specialist clinical social worker. Yes, that's what LSCSW stands for. Acting as the individual and family therapist for the aforementioned child, Melanie. Melanie entered into therapy services February 2025. I am writing at the request of the mother, Ms. Monica Ashdown, regarding the co-parenting and custody of Melanie. Clinically, I feel it is appropriate that Melanie has a safe and stable environment to work through the developmental stages of early childhood and that her needs are prioritized within these environments. This would include housing that is consistent and includes her own bed and independent space. I have concerns about ongoing reports of Melanie's father's drive to have her continue to co-sleep to the point of interrupting developmental tasks of childhood. Similarly, it often appears that Melanie and her father center his needs, leaving Melanie with feelings of anxiety and confusion. If any additional information is needed, please contact me. So that's the content of the letter. Now, given those things, and I acknowledge that there is a motion, on file, what is your position with the findings, with the motion to set aside and the findings that the court made, that is the existing order from the April 13th hearing that was filed on April 14th? Hang on just a minute. Amy, I have a 10 o'clock, is that right? Those parties are self-represented and it's in person in the courtroom.
Yes, I'm getting ready to take my computer in there. And I'll just go in there so that I can kind of address them and see if they're there.
Okay, so you're going to remove yourself from the hearing.
No, I'll stay in it. I'll just take my computer in there and put my earbuds in.
Okay, because you have not heard from security whether anybody's checked in or not.
I have not, but I just now reached out to them probably 6 or 7 minutes ago.
Okay, yeah, because it's 10 after 10. All right, very good. Mr. Gulick.
Your Honor, and to your question, sorry, that kind of threw me off.
Oh, I apologize. So your statements, your position.
Yes, Your Honor.
With regard to the motion that was filed and the orders that were entered, and then your motion to your current motion that I'm considering to set aside the orders.
Yes, Your Honor.
And essentially give you an evidentiary hearing.
Yes, Your Honor. As for the therapy, I've never once been concluded on that. I have no idea what's going on. They do not call me. They never send me letters. All I know is it gets used against me every single time. As for Melanie and me forcing her to sleep in here, as my witness behind me, the last 2 weekends that I have made her sleep in her own bed because it has been on the court order, she has screamed and cried to try to sleep with me. I finally got her comfortable enough to sleep in her own bed 2 weekends ago. I stayed in there next to her bed with her because she was scared. And yes, we are at Grandma's house. I live here at Grandma's house. My stepdad died. So I moved from my residence in Benton, where I had lived for 3.5 years with my brothers, no random people, with my 2 brothers, her uncles that love her to death. And I do everything I can. My motion, I never would have filed if I didn't think there would be record of me being in that courtroom that morning. Because I know people, I know hearsay, I know you probably get it 5 times a day. I was there, and there's no record. I never would have fought this if I thought there wasn't going to be a record, because it's just going to make me look worse. I love that little girl with all of my heart.
Okay. Is this the only child that you have?
This is the only child I have.
All right. Ms. Ashdown, is this the only child that you have?
Yes, Your Honor.
are there any statements that you want to make to the court with regard to all of this?
The only thing I have to say is with the evidence that has been shown, I don't understand why we would stay my motion. Sufficient evidence hasn't been shown, and I'm not taking away parenting time. I'm just trying to promote stability and consistency.
Okay, well, you are taking away parenting time because
I don't want to fully remove Mr. Gulick as a parent by any means at
Okay.
all.
All right. All right.
Honor, Mayor.
No, I'm done. I'm sorry. I've got all day cases. At some point I have to make a decision. Miss Ashdown, in all fairness, as hard as it is, and the effort that you made to give notice is way beyond what most attorneys do, honestly, by getting him personally served, by communicating with him the day before. I understand through no fault of your own that this is frustrating because you believe that your request had merit and that you would have liked to have heard it when it was scheduled, and for the court to do anything other than what the court's done, it is unfair to you. I do appreciate how you probably feel about this. But whether it's today or tomorrow or a month from now, I would hope he would present something by motion that he's remedied any potential issues and that he gets involved with therapy. But even if it's a year from now, these issues on their merit will have to be addressed by the court. And had he waited a week or a day or 2 days to start contacting the court, and because he overslept and he forgot the date and he didn't pay any attention and it wasn't important to him, it might be different. But because the law prefers that the court not make findings based on default, but rather makes findings based on the merit of an action, and because he, within the hour, whether it was because you notified him or he inquired what happened at the hearing, I'm not sure. I don't believe that he was during the hearing trying to participate in the hearing that he was unable to participate in. I do not believe that. But be that as it may, I do believe I should set aside the motion based on complete default, just adopting everything based on default. However, so I am setting aside the order as it appeared as a default order. However, Mr. Gulick, now that I've received a letter from the therapist and the child's in the with the therapist, and the child is 8, not 8 months, not 2 years, the child is 8. Some children are going through puberty as early as 8, 9, and 10 years old. It's amazing to me, but there are plenty of young girls who are going through puberty at 10 years old. Given her age, and given the statements of the therapist, I do believe that there's cause for the court to intervene and modify your parenting plan. Now, I will give you a full evidentiary hearing to revert back or to listen to any additional findings that you think the court shouldn't have made or should make in this matter. But even though I'm setting aside the order, based on what I know today, I am going to enter an order, and I'm going to call it temporary in nature because it's based on circumstances that were of immediate need to address, as far as I understood it. I am going to require that your weekend visitations be at your mother, and that you continue to work with your child to feel safe and able to sleep in her own space and develop as an independent child. You know, it's one thing if a child has a nightmare during the night and comes to you. It's another thing if the child doesn't have their own space where they feel some independence, where they can be independent, you know, where they can make their bed, where they can put their personal items, where they can go to sleep. You know, it's one thing if a child wakes up and comes to your room and needs comforting because they've had a nightmare. But it's another thing just to let them just be in your bed all the time. And I don't think that's a good idea. And I don't think shifting places that you're having the child overnight, given your child's apparent attachments, is a good idea either. So whether you like it or not, nope. Whether you like it or not, I'm requiring that your every other weekend, I will allow overnight, and I will allow Friday to Sunday. It must be at your mother's. And for the next 6 months, your mother must be present so that she can vouch that your daughter is at her house. And if you don't wake up or something, grandma's there to comfort her, but also encourage her that she has a place, she has a home with you, she has people that love her, and you're all there for her, and that it's okay, and that she can sleep by herself, and that you'll work through it, just like you've worked through everything else, potty training, whatever else that you work through with children that, you know, they may initially be resistant to. So, Ms. Ashdown, you, if I haven't let you respond to this, but you must make sure that this therapist has all of Mr. Gulick's information and that she has consent to converse with him and that he's allowed to be involved. So those appointments that you have need to go on our family wizard so that he can see when they are. And it's up to the therapist how she participates. She may talk to you as much as she wants, as little as she wants. You certainly can communicate to her, but whether she reciprocates that or not, that's her domain based on her ethical responsibilities, based on who's paying her, based on whatever. I'm not gonna interfere with that. And if you have a problem with it down the road, you can take that up with the court. But
Sure.
I do want you to be on the list of contact people and on the list of people who can have information.
Sure.
And if I need to make that part of the court order, I will. And I do want the appointments put on our family wizard. Now, don't expect this. You shouldn't have to be hand-fed by mom every time you want to know something. So don't expect that she takes the child to the therapist. You're not communicating with the therapist. You don't show up to make yourself available to the therapist. But then after the fact, you want to talk to mom and have her tell you everything that happened. Are you following me?
Yes, Your Honor.
Okay. All right. So, you did not have the one night a week prior.
No,
So
no.
let me ask this, Miss Ashdown, has he been exercising and giving you notice and doing any after school time once a week on the off weeks that he doesn't have her?
Over the last month that my order had been put in place, he exercised that time one time of the 2 weeks.
Now, why is that, Mr. Gulick?
I never got a court order sent to me from the last court. I actually notified Miss Ashdown of that. I never got that. And I had asked her more than once to get Melanie, and she had reminded me that on the off weekends, I'm not allowed to have her. And on the weekdays that I don't, or that I do not have her, I can have her for one day, but then she told me I couldn't have her 3 of the 4 days, and I can only have her on Monday or another day because she's too busy.
Okay.
At my
All
convenience.
right. Let me ask this. Miss Ashdown, do you think it's better that he have a designated day of the week so that it's consistent for your daughter, or that on Sunday he designate the week that is the off week, that he designate what day he's going to take that next week, and that would be fine?
For our schedule, okay. Our child is a very active child. She has therapy consistently. She has Girl Scouts every Wednesday, which is concluding, so that opens up that weekday. She is currently entered softball season, so we will be doing practices and games and the like. I left it open so that the decision was up to Mr. Gulick to engage in his own parenting time at his own will.
Okay. Well, when does Girl Scouts start back up?
When the school season starts back up.
Okay. And it's just one Wednesday. It wouldn't be 2. So even when Girl
It's
Scouts
every single Wednesday, usually.
no.
Oh, okay. Sorry.
That's okay. What I'm saying is, if he has in a 2-week period, he has his weekend, then he has his off week. If he has one Wednesday, you still have another Wednesday to go to Girl Scouts, and you both can participate in Girl Scouts, which is what you should be doing, both participating in her activities. So what I am going to order is that on your off weeks, you may have Wednesdays from after school or 3:30, whenever school gets out, if there is no school. Why 6? Does he not feed her? Why 6 as opposed to 7, since she's 8 and it's going to be Sunday?
I just usually get home about 5:30 or 6 o'clock. So it just kind of made sense to pull into town and stop at the sheriff's office. He has been feeding her as far as I'm aware. He'd fed her last time. So we usually start our bedtime routine about 8 or so. She goes to bed about 8:30.
Okay. So, and then summer's coming up. So how far do you live from your exchange?
I myself live a block away.
Okay, so you can go home, run home, change, let out the dog, whatever you do when you get home, fix yourself a sandwich, whatever, and run back over at 7. Okay, so I'm going to give you from the 3:30 to 7 Wednesdays on your off weekends. And I really added your time. I restricted you to being at your mother's for overnights for now. So you haven't lost anything by me setting aside and entering these orders, other than some accountability for a while and some consistency at your mother's. Okay, so in the event that you have a conflict on that Wednesday, you must notify her by Sunday night at 7 p.m. on our Family Wizard that you're not going to be exercising Wednesday.
Yes, Your Honor.
So that she can make her own plans accordingly.
Yes, Your Honor.
And you have to be consistent, because I will take that time away from you if you don't use it. That's what I do to parents. You want it, you get it. You don't use it, it gets taken away.
Yes, Your Honor. I'll use every second of it.
Okay. And then that gives you, when Girl Scouts start up, that gives you an opportunity to take her to Girl Scouts, meet her little girlfriends, volunteer, bring some crafts, whatever. to stay connected. So I've given you that opportunity. I've given you opportunity to connect with the therapist. She's going to provide you with the softball schedule. You can go to practices. You can go to the games. You have all that.
Sure.
And any other thing you can, it's always open to amicable agreements. However, I don't allow for people to pester, intimidate, bombard any of that with the other parent, which is why I prefer to have particular days. I prefer to have particular time so that parents aren't constantly trying to change things with each other and renegotiate, and because it can lead to arguments, friction, tension, and all the things that we don't want when people are co-parenting.
Yes, Your Honor.
All right. Now, this plan, I'm going to enter it as an order. I'm not going to call it a temporary order. It is an order. I set aside the original order. I modified the original order. I put the original order in to place. Ms. Ashdown, you're not his attorney. You aren't his mother. But given the fact that you so quickly journalized the last hearing and did a fine job, and I'm afraid if I give it to Mr. Gulick, I may not get it immediately. Would you be willing to journalize the order of the court today? All right, then send it to him.
Just to clarify, that was
Sure.
Friday to Sunday, 6 to 6, correct?
The same time, the same schedule you had before I modified it. Yeah.
Okay.
Yeah. So
Can we
I'm
keep
just reinstating.
can we keep pickup drop-offs at the sheriff's office?
Yes, everything stays the same. I'm adding the requirement that grandma, I assume she stays the night at the house, but it be at grandma's house and there be a bedroom and a bed and a designated place and consistency. Grandma, I'm not going to hear from you today. I'm sorry. Unless it affects the health or welfare of the child to the extreme extent that you think I need to know it right at this minute, I've got to conclude this hearing. Now, I'm not making this a temporary order, but I am going to make a finding that it is for consideration, for modification, for two reasons. One is if mom wants a full evidentiary hearing on this matter, in person, witnesses, she can call all the witnesses she wants to, she can present a full case, you have to present a full case, and you want a full evidentiary hearing on the matter, then that can be requested. Or we go 6 or so months out and you want to file to make a minor modification of, hey, my mom goes on vacation on these days, she's not always here, I want to be able to take a trip, whatever, that I will not require that either one of you show a material change in circumstances to modify the order. Are you following me? Because orders require something more than just a parent wanting to change something, to have a hearing, to do modifications. I am going to allow you to have a hearing before me without filing a modification fee and without proving to me that you have a legal basis to have a motion and a hearing for the next 6 months for those reasons only.
Yes, Your Honor.
If you want anything else, then you have to go through all the, if you want to make other major modifications to the original parenting plan or the parenting plan that I've adopted, then it will require that you meet the legal standards of material change of circumstances and that threshold. The only other matter is if you have disagreement with what's been set out as an actual holiday parenting schedule, I need that in the next 14 days.
Sure.
So Ms. Ashton will send you the proposed journal entry from today's hearing and my findings for you to review and sign. She will file them with the court under a Rule 170, which means I have sent this to the other side. This is what I'm proposing. It will be filed without his signature if he doesn't either sign it and agree to it, and have it filed, or object within 14 days to what's in it. The only thing you can object to is if you think her order doesn't properly state or summarize what happened at this hearing and my rulings. Again, attorneys do this. This is used, it's done. That's why it's an adopted Supreme Court rule. But I want, it's sent to you if you think that there's something that's missing that you can just, again, communicate through the methods that have been authorized, but you want to say, hey, I thought it was this time, not that time, or whatever. And then if she doesn't agree, oh yeah, that's what the judge said, then you have to file an objection within 14 days. Or if you don't sign it, which is what I prefer, is to be signed by both parties and filed with the court, then if you don't sign it and you don't have objections in 14 days, then I'm going to adopt it as is.
Yes,
Unless
Your Honor.
I see something glaring that I know there's no way I ordered it. Okay?
Yes.
All right. I've tried to explain to you as much as I can. I've given my rulings. I think there's enough finality to it if you wanted to appeal my rulings to the Court of Appeals in Topeka that you have 30 days to do that. Otherwise, I think for now we're adjourned and I'm not going to schedule another hearing at this point. Okay?
Yes, Your Honor.
Stephen claims he does no wrong and plays the victim card. But dodging all the paperwork makes co-parenting hard. He skipped his weekday visit, waiting on a printed sheet, and slept right through the hearing while the judge declared defeat. You say that the little one is always on your mind, but empty words and missed alarms are all she'll ever find. True parenting takes action, leave your selfishness behind.